next presenter, Marina's background, property law was a favorite subject when she studied at Wits University. It is this passion that led her to specializing in the field for 18 years. And in legal and property circles, she's regarded as a sectional title and community schemes guru. She's a best-selling author, having co-authored the first consumer-friendly South African book on sectional title property issues entitled Demystifying a Sectional Title. Great title. So she has published numerous articles for magazines and newspapers and lectures locally and internationally. She has trained an unrivaled team of specialist lawyers and consultants at BBM Law who work with her in her firm's sectional title department. And her accreditations include mediation qualifications from the London School of Mediation. She's a fellow of the Association of Arbitrators. And in 2015, she received an award for excellence in law from the Lyceum Club of Greek Women. Her name is Marina Constas, and she heads up a firm called BBM Law. And the title of the presentation today is The Top 3 Legal Challenges in Community Management Answered. Welcome to you, Marina. It's over to you, and nice to have you on board.
Thank you. Thank you so much, Neil, and thank you so much to the team at REMAG. It's always great to be speaking to managing agents. I have worked with managing agents as my largest clients for actually now almost over 18 years, just over 18 years. And working with them, I've understood their challenges, I've understood the problems that they encounter on a daily basis. And I think it's all about what this webinar is about. It's all about adding value. And while times are tough now, I think this is the opportune time for all you managing agents out there to really grab owners and trustees firmly by the hand and lead them through this difficult period, the next year or so, where we've got to navigate these waters and really make sure that you're there, make sure that you're supportive, make sure that you are giving extra value, going the extra mile, because those people will remember that, certainly when the dust has settled. So it's all about value, value, value. So don't you think as a managing agent, sometimes you might feel as though you're working in a vacuum? You know, you go to your office, you work at your desk, you might see other managing agents, you know, at certain occasions during the year, or you might make phone calls to them. But actually, it's so exciting to really understand what managing agents are doing around the world. And the first thing I can tell you, and the first bit of advice or good tip that I can give you is to look at a certain book. I'm going to tell you about it. I met a professor in Sydney, New South Wales. Her name is Hazel Easthope. And she was interviewing attorneys and managing agents around the world. So that was Hong Kong, Singapore, Dubai, New South Wales, the United States, and England, about their various challenges. And it's so comforting to know, she's brought out a book, and it's so comforting to know that managing agents all over the world really, really face the same problems. And I'd like to show you the book, The Politics and Practices of Apartment Living. The Politics and Practices of Apartment Living by Professor Hazel Easthope. Really, really great book if you want to get the context of being a managing agent in exciting times. I will get this all out to you as well after I've spoken, and you can certainly contact me to get more details about that. So in the book, they talk about levels of dissatisfaction with managing agents and surveys that have been conducted around the world. And just very interesting, short sort of briefing. Your managing agents in, for example, New South Wales, the survey found that there was 27% dissatisfaction with managing agents there. In Boston, New York, and Washington, 27% dissatisfaction with managing agents. And in the UK, they found an astonishing 66% dissatisfaction with the services of a managing agent. It's impossible as a managing agent to please everyone. I mean, I know the seas that I fish in. All my managing agent clients have the same kind of issues. Low margins, trustees who are demanding and who really, really, want to get their pound of flesh from you. Then you also get all the owners who think they're your boss. Not only that, you've got regulation. So you've got all these new acts, Community Scheme Ombud Service Act, Sectional Title Schemes Management Act. And then you've also got technology that you've got to be up to date with, and you've got to understand and suddenly make sure that you're really sort of high tech and working hard. And to top it all, you've got the COVID-19 pandemic. So yeah, it is really, really tough out there. We understand it. But for me, I've kind of put together the three main challenges that I think that you all face. The first one is understanding the rules of the scheme, understanding the management and conduct rules of the scheme, and educating your trustees and educating your staff. So why is it important to understand management and conduct rules? Well, because these rules are actually the lifeblood of the scheme. And if you have a set of well-drafted, intelligent, legal rules that are robust, you're going to face fewer attacks from the outside, from owners, from tenants, even from service providers. Even your managing agency contract needs to be worked and really, really professional, and set out expectations pretty clearly. So the Sectional Title Schemes Management Act says that rules need to be reasonable and need to apply consistently to all owners. So this is the first time you can take your trustees by the hand, or your directors of an HOA, and say, let's sit down, let's see if at the moment your rules comply with everything. Will we get a compliance certificate from the Community Scheme Ombud Service? Because you will have to get a compliance certificate if you're going to change any of your rules. So I sat on the Community Scheme Ombud Service Board for 2 years. And it was during that time in the legal department that we went through the rules, and the Community Scheme Ombud set out which rules would be acceptable and which rules would be kicked out and would be struck out. And we've got to remember Section 39(3) of the Community Scheme Ombud Service Act basically gives the Ombud the right to strike out rules, to amend rules, to substitute rules, and even to add new rules into a scheme's conduct or management rules. So why face that hassle? Why have that battle with owners trying to interpret rules? Get the rules right from the word go. So again, it's fundamentals and it's adding value to your clients. So I thought it would be interesting just to go through a couple of the rules where the Ombud gave really, really good inputs, and which is a starting point for managing agents. And the first one is, you're not allowed to have discriminatory rules in your scheme. You're not allowed to exclude people. So you can't exclude certain races, nationalities. You can't exclude people for being too young or people for being too old. If it's a retirement village, then of course you've got to register as a retirement village. So that's a separate thing. And also you can't have these kind of rules where, for example, you've got a rule saying that trustees can interview owners and can interview prospective tenants just to see that they're the right kind of caliber of person for that sectional title complex. That wouldn't be allowed. Illegal rules are not allowed. So you can't evict owners, you can't evict tenants as the body corporate. Only an owner can evict a tenant. And an owner has to sell or die basically to be removed from the complex, which I'm sure is quite sad news for some trustees. You can't cut electricity without a court order. You can't restrict access to a person who's in arrears with his levies, and you can't stop services if a person is in arrears with their levies. So those rules are a waste of time to put into your conduct rules specifically. One of the most common questions I get asked about penalties. So penalties, can you put penalty clauses into your rules? Yes, the Ombud will allow a penalties clause, but then at the same time, you have to have a clause which gives you the right to be heard as well. You can't just impose a 2,000 Rand levy on somebody, penalty on somebody. You have to give them the right to come forward and state their case. Otherwise, that penalties clause will just be struck out. Short-term letting, really contemporary issue, and there's been an onslaught with regard to short-term letting, particularly pre-COVID-19. So get up to speed with what's going on in short-term letting, and put a rule in. If you want to prevent short-term letting in a complex, you can put a rule in to say no short-term letting, and then the Ombud will uphold that. But we're still waiting, of course, for the Department of Tourism to take over that role with regard to short-term letting. Ritual slaughter on common property used to be able to say it's banned. With the Ombudsman has now said, no, you can't ban that clause. You can allow ritual slaughter as long as you keep up with the Meat Safety Act, where fees paid and all those type of things are looked at. So get up to speed with understanding your rules and also educating your staff. In that book I was talking about the politics and practices of apartment living, one of the attorneys from Massachusetts raised the fact that managing agents are doing themselves absolutely no favors by lowering the bar in terms of the fees they charge, because you need a little bit of fat in your fees for training your own staff. Not only training your own staff, what about looking at training your trustees? Because a more educated, more sophisticated kind of trustee is so much easier to deal with. You don't have to explain all these legal challenges to them. Look at Regulation 14 of the Community Scheme Ombuds Service Act. That says that trustees, or they call them scheme executives now, scheme executives must inform and educate themselves about not only the legislation, but also corporate governance documentation and all the affairs of the body corporate. Well, wow, brilliant. What an opportunity for you as managing agents to step in there and to train people with things like brochures, newsletters, information sessions, even conflict resolution sessions. And I know that there is, again, there's a cost involved in that, but that's really something to be able to distinguish yourselves. I've always been very much in favor of mandatory trustee training. And in Florida in the United States was the forerunner of that. So their legislation says that as soon as you become a trustee, within 90 days, you've got to attend a half-day workshop. In Canada, followed suit, and they said within 90 days, you need to do a workshop as well. I think 90 days is a bit long because most trustees might have dropped off after 6 months. The second challenge that I want to talk about today is about technology in unprecedented times. And of course, you know, we have to up our skills, both attorneys and managing agents, when it comes to technology. And we've got so many brilliant options. I mean, you just have to look around you today on this webinar for all the brilliant options. And just this morning, I got an email from a colleague of mine in Australia. His name's Francesco Andrioni. A lot of you guys will actually know Francesco, and he's involved with technology. And he was tabling some of the really exciting things in strata law in New South Wales. But we stuck now with online meetings, or it's been thrust in our faces all of a sudden. And the COVID-19 pandemic has just set us all, you know, over the edge. I think it's a brilliant thing. I think it's somewhere we needed to go. And video conferencing is important. It's something I'm sure everybody has experienced, the online Zoom meetings. And it's specifically authorized in terms of Management Rule 1710 of the Sectional Title Schemes Management Act, as long as with the proviso that everybody has access to it. There's a bit of a challenge for you because you've got difficult people in sectional title who will say, I don't really want the meeting to happen, so I don't have access to any kind of computer, I don't have access to software or signal. I think it's a rather feeble excuse in today's day and age. And we're looking at things like hybrid meetings where other people in the complex can share their support system. So 2 people can sit in one unit and 4 people can sit in a clubhouse, and you can hold your Zoom meetings there. The benefits, of course, are really big. Every managing agent I've spoken to has seen the benefits. First of all, you get a quorum in a much easier way. Secondly, the chairperson's got more control over the meeting, so you can mute or unmute people, which is really a powerful position to be in. Also, what I like about it is there's less, you know, inappropriate conversation. People get to the point. People are punctual. There's no traffic. There's no venue hire. Great thing, you can record the meetings, which is often a bugbear. And in a few meetings I've attended, people can Zoom in. So your service providers can actually Zoom into the meeting and give their proposals and presentations. So I think that's an advantage. We've started an initiative called Women in Sectional Title, and all the women that I've spoken to, portfolio managers, have been really, really happy about being able to stay at home and conducting Zoom meetings, evening meetings, AGMs and special general meetings at home. And that's just worthwhile in itself to have relaxed portfolio managers. I think it would prevent the sort of high turnaround that you get in terms of employing portfolio managers well. So what are we talking about now as well is I think you also need to look at tips, practical tips about these meetings. Practice your AGMs, practice special general meetings, put written resolutions down or video your resolutions and send them out before the meeting so that there are no outstanding issues or questions or whatever. You can just get them passed. And certainly a how to start a Zoom meeting or how to look at Microsoft Teams would be a good idea to train your owners, just to get them up to speed. Obviously there are problems. I mean, there's no doubt that you've got problems with it. You've got load shedding, you've got loss of signal or connection, and that can be a real issue. I mean, if you form a quorum at the beginning and you lose connection and you don't have a quorum, can you transact business during that time? I don't think you can, but those are the kind of things that you have to grapple with. Voting can be an issue, but now you can buy or rent apps, voting apps, which will assist in that, where somebody actually takes over the voting and streamlines that whole process for you. You can use the chat function or Google Forms as well. But again, there's no excuse not to go online. And for me, I think people are going to stay online. I think there's a huge cost saving. And I certainly think that it's time saving as well. I'm also talking about unprecedented times. So with the online thing, you've also got the challenge of what people want to do during these unprecedented times and where COVID has brought us to. And something that you're really going to encounter as managing agents is running a business from home or home-based businesses. And your home-based business is going to be a thing where you've got to look at things like the law, the bylaws. What does the Body Corporate Sectional Title Management Act say? The Management Act says that you've actually got to get the written permission of every single owner if you want to change the purpose of use for your section. That's section 13(1)(g) of the Sectional Title Schemes Act. Section 13(2) goes on to say if any owner is upset about that and feels that they were unfairly prejudiced, if it was unjust or if it was inequitable, then they can go to the Ombud straight away, the chief Ombud, who will be able to then make a decision and substitute that. But then there are the municipal bylaws, really, really important. And the municipal bylaws say that, for example, you can't run certain businesses at all in community schemes. So motor car sales, heavy machinery equipment, you can't put there. Pet salons, spray paints or panel beaters can't be in community schemes, even restaurants if there's not the right zoning. Also, you can't use more than 25% of your floor area to run a business. And the guy running the business has to be the guy owning the unit. So you can't just bring in 2 or 3 other people to run your business in your unit. So these are important things to look at. And my tip for the day on this is to say, put it in your rules. Ask the trustees to put it in their rules with the municipal bylaws, place them into your rules. So they're great expectations, which can't be exceeded. And everybody knows where they stand. But also be open to the idea. Be open to the idea of running businesses from home. It's a reality. It's a thing of the future. And if you craft those rules correctly, I think you can more or less, get away with it. But again, that will be organic growth. Last thing, third thing, arrear levies. I mean, obviously we know that this is a big one. If people fall behind with the arrears, there are problems with the operational daily running of the complex. There's problems with maintenance. There's problems with salaries. You can't get the right caliber of person if you can't pay them. So how do we go about facing this problem? You can stand on your head as a managing agent and whistle Dixie. And you can put on great trustee education programs. You can host cocktail parties at the top of buildings. You can do whatever you want. If the levies run out of control, it's the biggest reason for your mandate to be terminated as a managing agent. There are no shortcuts here. There are really no shortcuts. So basically what you need to do is you're going to go to litigation or you're going to go to the Ombud. And at the end of the day, this is a business you're running as the managing agent and as trustees. You have to have your credit controls in place. You're not allowed to switch off electricity, we know. You're not allowed to restrict access. There are all these things that you're not allowed to do. And we know that it takes time from a court point of view, and I think the Ombud will certainly be better placed in a year or two to deal with the real levy collection. But at the end of the day, you've got to strike while the iron is really, really hot, and you've got to get the fundamentals right. What can you do as the managing agent? Make sure that you're telling people to get a resolution from the trustees after the AGM on the amount of the levies. So the levies, unfortunately, there was a case in the Western Cape called the Body Corporate of the Peaks versus Prinsloo, where they didn't get that resolution from trustees directly after the AGM on the amount of the levies. Mr. Prinsloo walked away after owing thousands, hundreds of thousands of rands in levy. So you need that resolution. The interest resolution also, please, for managing agents, get it. You can't claim interest at court or at the Ombud if you don't have that written resolution in place. Levy budgets for legal fees. Put a budget in for legal fees. You can get your taxed costs back on your legal fees. So, for example, if you're doing a disconnection application for electricity, which costs 15,000 Rand from an attorney, which is on an unopposed basis, you're getting back about 14,200 on a taxed bill of costs. So please, you really need to look at doing that. Keep things tight, but also look at the Community Scheme Ombud Service Directive about COVID-19 and the pandemic. It's important that you look at maybe installments and paying off agreements for people who are really, really battling. At the same time, make sure that you get the evidence that they're battling. My experience is that the ones who were battling before just use this as an excuse to go forward to say we can't play our levies. To end, I'd like to leave you with this thought. International trends, the international trend is towards creating aspirational communities. So it's as much about building social and civic well-being within a community rather than only focusing on maintenance and enforcing rules. So it's, internationally, managing agents are looking at a more leadership and inspirational role. So it's engendering this feeling of more care for the building and shared responsibilities between the managing agency and the community. And of course, yes, these soft things come at a cost, but there you've got to look at building that in any industry in order to remain relevant and to remain sustainable. You've got to look around you. You've got to look at what other people are doing. You've got to look internationally and see what improvements can be made. And certainly sectional title management is no exception to that at all. I'd like to thank Remag again and We Connect You. Thank you to Neil and to Dani. This has been a fantastic opportunity. My presentation will be available if you email me on marina@bbmlaw.co.za, and we'll throw in the 10 top tips from this webinar. So thank you very much.
And we get people to buy your book as well. Marina, where can they get your book?
Yes, demystifying sectional title on the website. Thank you.
Okay, great stuff. Thanks very much, Marina.